bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Can you call those Spanish cases with the case numbers for the interpreter, please? They need case numbers. Just give him the name of both of them and the case numbers on both of them, so he'll have them. They keep a record of them.
Jonelle Lopez, case number 21286 CTA.
And the other one?
Christian Lopez Ocasio, 2021 MM 881.
Thank you.
Sí.
Interpreter is connected to the podium, Your Honor.
All right, thank you, Mr. Interpreter. Are you Janelle Lopez?
Sí.
Yes.
Right. Mr. Lopez, you were picked up on an out-of-county warrant from Seminole County. The bond is set at $500 in that case. I am appointing the public defender to represent you in this case. Do you have any questions, sir?
No.
No.
Thank you. Are you Christian Lopez Ocasio?
Sí.
Yes.
Mr. Lopez, oh, sorry. On this one? Okay. Thank you. One moment, Mr. Lopez Ocasio. All right, Mr. Ocasio Lopez. You were picked up for violation of your probation. The following conditions: Condition 4, committing the offense of tampering with a witness on or about September 2nd, 2021. Condition 4, committing the offense of aggravated stalking after a court prohibition on or about September 2nd, 2021. Condition 4, committing the offense of violation of pretrial release conditions on domestic on or about September 2nd, 2021. And special condition, failing to have no contact or communication with the victim, Gabriela Velasquez, including but not limited to face-to-face contact, electronic, or phone contact. So you can admit or you can deny the violation of probation. If you deny the violation of probation, your case will be scheduled for a violation of probation status. If you admit, there's a recommendation, a sentencing recommendation to revoke and terminate your probation and sentence you to 365 days in jail with credit for your time served. I believe you have 24 days time served. And that you enroll and participate in the cognitive behavioral change class. Of course, you do not have to accept that recommendation. It's just a recommendation. I am appointing a lawyer from the public defender on your case, and you can consult with the lawyer before making a final decision as to what you wish to do.
Your Honor, I believe, for my system, we filed a motion to withdraw. He has private counsel.
Oh, okay, I see that. Well, I see from what you're saying. Actually, I will not be appointing a public defender, or the public defender has a pending motion to withdraw from your case. So you may wish to, communicate with your private counsel if you have retained private counsel. But keep in mind that there is a recommendation that has been made regarding your case. Do you have any questions, Mr. Lopez Ocasio?
Nope.
All right, bond remains set at no bond. Yes, you can go ahead and give him a VOP status. Yes, VOP status. Yes. Thank you, sir. Tyler Blue Johnson. Mr. Interpreter, I think that's it for you.
Very well, Your Honor. Thank you.
Mr. Johnson? Hello?
Hey.
Hey. You were picked up for violation of your probation, condition 5, by failing to live without violating any law and being arrested for the criminal offense of battery on 1/25/22. And condition 5, failing to live without violating any law and being arrested on another count of battery on a uniformed or licensed security officer on 1/25/22. And sir, you can admit or you can deny your probation. I don't have a recommendation in your case, so we're gonna enter a denial. Oh, we don't? Well, what do you do? I'll appoint the public defender and a hearing will be scheduled at some point in time. When? Like immediately, today, or? Okay. She has a docket. She says VOP. Yeah. I'm ready.
Omari Landry, refused, Your Honor.
All right, he refused yesterday too.
I'll waive the appearance, Your Honor.
All right, thank you. Omari Landry is waived. The court does find probable cause for the following offenses: possession of cannabis with intent to sell or deliver, bond is set at $1,000. Possession of cocaine, bond is set at $1,000. Possession of a controlled substance, bond is set at $1,000. And possession of cannabis less than or greater than 20 grams, bond is set at $1,000.
Eric Walters, refused, also.
I will waive the appearance, Your Honor.
Also refused, yes. He refused yesterday as well. The court does. Let's see what I did in his case. The defendant had failed to appear. The previous judge, ordered mental health pretrial release. Do we know if he qualifies for mental health pretrial release?
You will have to see the mental health. And they,
Oh, sorry, I'm sorry.
determine if he qualifies for mental health PTR.
Your Honor, I would just ask that you do both, mental health pretrial release, and then if he doesn't qualify, just set a monetary bond. That way, if he doesn't qualify, he'll have,
It's unclear because the judge wrote both no bond, and mental health pretrial release. What division is this case?
He's been deemed incompetent to proceed, Your Honor, so I believe that's why they put the mental health pretrial release. That'll be my only thing, if he doesn't qualify for the mental health pretrial release.
Your Honor, they did attempt to give him mental health pretrial release last year. And January 5th, there was a notice saying that he did not qualify because he didn't meet the administration qualifications for it. So I doubt that anything has changed for him to be able to qualify for it this year.
Bond will stay set at no bond. Defendant to be evaluated for mental health pretrial release. If the defendant does not qualify for mental health pretrial release, refer the case to the division judge. Bond conditions, mental health pretrial release. If the defendant does not qualify, please notify the division and PD within 3 days of the arrest. So it's no bond. Evaluate for mental health pretrial release. If he qualifies for mental health pretrial release, then we'll release him on mental health pretrial release. If he does not qualify for mental health pretrial release, notify the division judge and the public defender within 3 days of the arrest. The state is informing that they do not believe he will qualify for mental health pretrial release, but I still want him evaluated.
That's fine.
Okay? What's the name on that, so I can text Judge? This kind of wondered. What's her date? 80? Caitlin. All right, I'll have Juanita read instead of me. Eric Walters. This number. 20. Please contact Caitlin or Judge Bigney and ask if she wants to release the above defendant on mental health issues without a bond or with a bond. Period. Also, determine if you want to set the case on status hearing. Period. The state believes that he will qualify for the mental health pretrial. Okay. Just hold it and we'll see what Judge Bigney wants to do with it. I'll keep it. That way, if you forget, I'll remember. Oh, you already put it to the side? Yeah. Well, just don't forget.
What's this?
Robert Watson,
He's mental health, Your Honor.
mental health. Ms. George,
I will waive the appearance, Your Honor.
all right. The court finds probable cause for count one, battery on a law enforcement officer. Bond is set at $2,500, and petty theft bond remains set at $100. Public defenders appointed.
Your Honor, can I ask for no return to the 7-Eleven?
Yes, ma'am. The court will also add a condition of no return to the location where this incident occurred.
Your Honor,
Yes, ma'am.
with regard to the case that we just passed, Eric Walters, I do have a copy of the denial letter. I can, if you.
When is it dated?
It's dated January 5th of 2021, Your Honor.
All right, well, Judge Bigney wants him evaluated for mental health pretrial release. So I'm not going to not order that, but I did note that you do not believe he will qualify, so.
If you allow me to approach, it's just the reason that they gave, it does not meet the administrative criteria. And due to that, I do not believe it would have changed, Your Honor. And that's the
Oh, I
only
see.
reason why.
Okay, sure.
One moment. I've already shown this to the public defender.
Okay. All right, I forwarded to Judge Bigney's JA, so she'll be aware that previously the person did not qualify.
Hey, Your Honor, just to verify for Walters, his open case for incompetency, you taking no action?
I wasn't aware of another case. But, yeah, I'll likely take no action. I just want to hear from the judge as to what she wants me to do, because it's unclear, because I see both a no bond and mental health pretrial release. With his mental health situation, I'll probably take no action, but we're gonna recall that case after I hear from Judge Bigney, okay? Clifton Joshua Dixon, hello? All right, the court finds probable cause for the charge of aggravated battery on a pregnant person. Bond is set in this case at $3,500. False imprisonment, bond is set at $1,000. Tampering with the witness to hinder communications, bond is set at $1,000. And battery, bond is set at $500. As conditions of the bond, the court is ordering that you have no contact whatsoever with the victim, that you not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to retrieve any personal belongings. You must possess no firearms or weapons as a condition of bond, and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. Thank you, sir. No, sir. Wendy Jacqueline Guajardo. Ms. Guajardo, the court finds probable cause for the charge of aggravated assault with a weapon. And bond is set in your case at $1,000 or pretrial release. The conditions of bond or pretrial release are that you have no contact with the victim, that you not return to the location where this incident occurred, with the exception of one time in the presence of law enforcement to retrieve personal effects and belongings, that you possess no firearms or weapons as a condition of bond, and that you surrender any in your possession, firearms or weapons, to law enforcement within 24 hours of your release. Thank you, ma'am.
Your Honor, could you announce the case number, please?
Would the clerk do it?
Thank you.
You're welcome. Kyle Lamont Moore. Kyle Moore.
Yeah, I'm double.
Okay, you think he already bonded? All right, there you go. And here's his paperwork. Christopher Anthony Gonzalez.
Yeah, he's bonded.
Christopher Gonzalez. Aaliyah Dye Smith Cardenas. Ma'am, one moment. Did you print this one for me? Okay. Here it is. I got it. All right, ma'am. The court finds probable cause for the charges of aggravated battery with a weapon. Bond is set at $3,500.
Your Honor, she does qualify for pretrial release.
I know.
I would
Can I
ask,
finish?
oh, I'm sorry.
The court finds probable cause for battery, felony battery. Bond is set at $1,000, and the court finds probable cause for domestic violence battery. Bond is set at $500, and you do qualify for PTR. If you're unable to post these bonds, then the court will order PTR, bond or PTR. Further, the conditions of bond or PTR are as follows. The court is ordering that you have no contact whatsoever with the victim and no contact with family members of the victim. The court is further ordering that you not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover any personal effects and belongings, that you possess no firearms and no weapons as a condition of bond or PTR, and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. Thank you, ma'am. Christopher Anthony Gonzalez. Christopher Gonzalez, the court finds probable cause for the offense of battery, domestic violence, and bond is set at $500 in your case. Further, the court is ordering that you have no contact with the victim, no contact whatsoever with the victim, that you not return to the location where the incident occurred, and that you surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release, and possess no firearms or weapons as a condition of your bond. Thank you, sir. Covante Pierre Magruder. Sir, the court finds probable cause for the offense of battery and orders that you have no contact whatsoever with the victim in this case, that you maintain a separate residence from the victim. The court is further ordering that you not return to the location where this incident occurred, that you surrender all firearms or weapons in your possession and possess no firearms or weapons as a condition of your bond. 500. Kenneth Lorenzo Neal. Mr. Neal, the court does find probable cause for the charge of battery in your case, and I'll order a bond of $500 or PTR. As a condition of bond or PTR, you must not have any contact with the victim in this case and not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover any personal belongings and effects. You must surrender any firearms or weapons to law enforcement within 24 hours of your release. And further, sir, you must possess no firearms or weapons as a condition of your bond. Thank you. Or bond or PTR. That's fine, sir. You do, paperwork says you qualify for PTR. Narendra Vikram Singh. Mr. Singh, the court, finds probable cause for the offense of assault, domestic violence. There's a witness that the attorneys may have questions of the witness. So to the witness, ma'am, raise your right hand to be sworn in.
Do you swear or affirm that the testimony you should give should be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, I need you to state your name and spell your last name for me, for the record, please.
My name's Tina Singh. Last name is spelled Singh.
All right, Ms. Singh, the lawyers may have questions of you.
Good morning, Ms. Singh. How do you know the defendant?
He's my husband.
Has something like this happened before?
The specifics of it, no, but he has had other situations with other individuals that I've witnessed.
And when you say other situations, could you give me a brief description?
I can give you one incident that had happened at my parents' house. Our daughter passed away, and he blamed my cousin for giving us COVID and being part of the reason why we couldn't see our daughter. And he blamed my cousin that he's the reason why our daughter is dead and threatened to kill him during the wake of my daughter at my parents' house.
I'm sorry for your loss. Are you afraid of him?
Currently, yes, because I don't know who he is anymore.
And while this case is pending, would you like to have contact with him?
No.
Is there anything else that you believe the judge needs to know regarding your husband?
I would like to request to see if he can have a mental health evaluation.
I have no further questions, Your Honor.
Does the defense wish to inquire?
No questions, Your Honor.
All right, at this time, the court will order a bond in your case of $500, and I'll order that you have no contact whatsoever with the victim. I will further order that, you will be allowed a one-time visit in the presence of law enforcement to recover any personal belongings or effects, but otherwise not to return to, where the victim is living. That's what I said.
I think he understands, Your Honor.
You must possess no firearms or weapons as a condition of your release and surrender any firearms or weapons to law enforcement within 24 hours of your release. State, do you have any additional conditions that you think are appropriate in this case?
No, Your Honor, not at this time, no.
All right. Ma'am, thank you.
Can I say one more thing?
Yes, ma'am.
I also filed an ex parte order this morning at the courthouse that detailed a little bit more of why I feel like he needs to have a mental assessment. I don't know, do I turn that in or?
Well, ma'am, there is a procedure for the judge making that determination. And that procedure really, at this moment, does not, what you're saying does not reach the level of where I would order anything regarding any mental health evaluations, but there is a procedure, and the procedure can be implemented. The state can put in their file that you believe that he needs mental health evaluations, and of course, his lawyer, who I've appointed in this case, can also make a note of it. But at this point in time, I am not ordering any mental health evaluations.
Okay.
Thank you. Hakeem Wilcher. The court does find probable cause for the offense of battery, domestic violence, and petty theft. And I see there's a witness, and so with witness, we do need you to raise your right hand to be sworn in. Then I need you to state your name and spell your last name for me.
Latia Woolard, Woulard. Do you swear or affirm that the testimony you should give should be the truth, the whole truth, and nothing but the truth? Yes.
Spell your last name again.
Woulard.
Thank you, Ms. Woolard. All right, and one of the attorneys may have questions of you, ma'am.
Good morning. How do you know the defendant?
That's my boyfriend and kid's father.
Has something like this happened before?
Nothing of this nature, but just arguments.
Were drugs or alcohol involved in this incident?
No.
Are you afraid of him?
No.
Do you live together?
Yes.
As this case is progressing, do you want to have contact with him?
Yes.
I have no further questions, Your Honor.
Defense?
No questions, Your Honor.
All right, Mr. Wilcher, the court will set a bond as to count one at $500, as to count two at $150. And as a condition of bond, you are ordered to have no hostile contact with the victim in this case. You must surrender any firearms or weapons to law enforcement within 24 hours of your release and not possess any firearms or weapons as a condition of your release. Anything else? All right, thank you, ma'am. Brandon Falzone. Mr. Falzone, is that who you are? Yes, ma'am. Okay. You were picked up on an out-of-county warrant from Broward County. Bond stays set at $15,000 on count one and $7,500 on count two. Thank you, sir. Shaylin Ramos Sola? Yes. All right, you all were picked up on an out-of-county warrant out of Seminole County. Bond is set at no bond on that. All right, I have my response from Judge Bigney on, can we recall that case? Oh, that's right. So I'll recall it. Recalling Eric Pagan Walters. The court has received a response from Judge Bigney's office as to Mr. Walters. Judge Bigney wants me to order, as I ordered before, no bond with mental health pretrial release. She wants him to be assessed. If he does not qualify, then Judge Bigney will set him for a hearing. You can go ahead and set it. Yeah, set it for the PTC. When is it? February 25th?
Hers is March 10th
That's fine.
at 1 p.m. in Tempe.
That's fine. Daniel Abukir.
He refused, Your Honor.
I will waive the appearance, Your Honor.
All right, I'll enter a denial to the violation of probation, appoint the public defender. And it's a felony, so you say they don't set those for here? Okay. Jose Acevedo,
He's medical, Your Honor.
I will waive the appearance, Your Honor.
as to Mr. Acevedo, I'll appoint the public defender. Enter a denial, and, thank you. Corey Deshawn Barnes. Mr. Barnes? All right, you were picked up on a warrant for violation of probation. Special condition, the Batterers Intervention Program, you failed to attend and successfully completed.
Don't,
And bond will stay set at no bond in this case. I am appointing the public defender to represent you, so if you have any information you want to provide about that, you can give it to your lawyer. Daquan James Felix. Mr. Felix, you are being violated on your probation for your felony probation for possession of a concealed firearm by associating with persons engaged in criminal activity. Bond will stay set at no bond in that case. Sean Robert Hill. You were picked up on a warrant for violation of probation for a condition in for using intoxicants to excess or possessing any drugs or narcotics. To wit, amphetamines, as shown by an analysis of a urine sample on 11/2/21. Another condition similar on 11/2/21, methamphetamine was found in your urine sample. Also on 11/2/21, benzodiazepines were found in your urine sample. And on 11/2/21, cocaine was found in your urine sample. Bond will stay set at no bond for your violation of probation. Thank you, sir. Do I have two copies of the same thing for this guy?
You did both his cases.
Okay. Well, bond stay set at no bond on both cases. Malcolm Moore.
It's Malcolm Moore.
Mr. Moore. Okay. Is there an affidavit in his case? No, there's a PC. It's on site. Yeah, it's here. I want to read this one first. So he has a VOP and a new? Okay. Mr. Moore,
Yes, ma'am.
the court does find probable cause for the following offenses. Count one, possession of ammunition by a convicted felon, bond stays set at $5,000. Count two, possession of 3,4-methylene, methamphetamine, MDMA, ecstasy, bond stays set at $1,000. And count three, possession of paraphernalia, bond stays set at $500. And there was an on-site violation of probation for which the court will order bond to stay set at no bond. Xander Douglas. Yes, sir. On Xander? Thank you. All right, Mr. Douglas, you were picked up on a warrant for violation of your probation. Count 4, condition 4, committing offense of simple battery on or about October 29th, 21. Condition 4, committing an offense of possession of a controlled substance without a prescription on or about October 29th, 2021. Lorazepam. Count 4, condition 4, sorry. Possession of marijuana on or about October the 11th, 2021. Condition 4, possession of drug paraphernalia on or about October 11th, 2021. Special condition, failing to perform 30 hours of community service. Special condition, failing to complete the advanced driver improvement school. And condition 8, failing to pay costs of supervision and being $300 in arrears. There is a recommendation in this case as follows: revoke and terminate probation and impose sentence of 365 days with credit for time served, with outstanding costs being referred to the clerk's payment program, and I believe the time served on this case is 2 days.
Your Honor, Mark Longwell on behalf of Mr. Douglas. The maximum sentence, I believe, for this offense is 60 days in jail. So he would be declining that recommendation at this time. And, but we understand the allegations and his no bond status, Your Honor.
Yes, the court is going to order no bond status in this case and enter the denial, and it will be set for a VOP status hearing.
Thank you, Your Honor.
Division 63, the VOP status is March 9th at 9 a.m. in 10B.
Let me ask you something, Mr. Longwell, because I saw you sitting over there with your mask on, but to me, you were just a man with a mask. You weren't Mr. Longwell. But most days, when an attorney is here, the clerks tell me there's an attorney and they take their stuff out and put it up front. Did nobody offer you that today?
I guess that tells me where I rank in the scheme of things.
You're important. You're important, Mr.
Well,
Longwell.
thank you very much, but I don't like to be too presumptuous, and I waited my turn, that's all.
Well,
But
okay.
thank you for that.
Well, in the future, make sure, because to us, you're just a man with a mask. I mean, I know you're Mr. Longwell now, but I didn't know. I mean, you wouldn't know I was Judge Faye Allen unless I took my mask off. And I'm sitting up here, so you know it's me.
You know,
The mask-
I knew from even your voice when I was on the live link watching, but
Oh, well, I guess you're better than me then. Okay.
I appreciate that. It's nice to see you.
All you have to do, though, is let me know, and I would have put you in front of, I've done that earlier this week with some people who are private attorneys.
Thank you. I don't even mind watching. I learn sometimes just watching.
This is my law clerk, Sydney. This is Mr. Longwell. He's an attorney here in town that handles criminal cases and other kinds of cases.
Nice to meet you.
Nice professional man who sat quietly and did not use his status as a well-known professional man who I know well, but I mean, these masks, I was in the parking garage and I saw a judge coming towards me with a mask on, and I was like, that's either Judge LeBlanc or Judge Weiss. And I did not know which one it was because they were wearing a mask, and I know both of them very well. And the closer the person got to me, I realized it was actually Judge LeBlanc, or was it Judge Weiss? I will never know.
The age of the mask.
I just said hi, so I didn't have to say a name. But anyway, thank you.
Thank you. Nice to see you.
Good to see you. Thank you too. All right, thank you. Am I done?
Yes, ma'am, Your Honor. McNulty refused. Yes, special mask.
All right. Can my law clerk do like a limited tour? Like, you don't have to take her like deep into the pits of the jail, but can she see some stuff? All right. You want that? Hi. Holly McNulty,
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
in due course. Did I see that private attorney coming here, Mr. Thompson? You ready for the Spanish? I don't know how I feel about this, because I just don't understand why I'm being asked to do that. You do it, and then people forget they asked you to do it, and then they're like, why did you do it? Okay. Spanish, correct?
Spanish first?
Well, I'm asking. Give me 1 second. Okay, I mean, I'll do it however you all tell me.
We got. Yeah.
I'm gonna just go ahead on, I mean, I see an email, I don't know who. I'm not really 100% sure about this, but whatever. Looks like the emails confirm it. Okay. I'll just tell Juanita to keep the email.
No. Medical.
She can come tomorrow.
Get that out of the way.
I didn't really go down there, so I don't know.
Oh, okay. Okay, we'll try.
All right, we're back on the record for our afternoon session. This is Judge Allen. Counsel for the state, Ms. Eugene, announce your presence, please, with your spelling of your last name, followed by counsel for the defense. And then, Ms. Eugene, I want to call the case.
Brenda Eugene, on behalf of the State Attorney's Office, last name Eugene, E-U-G-E-N-E.
Thank you.
Letitia George, on behalf of the Office of the Public Defender. Last name is George, George.
Thank you. Ms. Eugene, I'm calling Marcus Markel Patterson, case number 2021 CF 15125AO. Defendant's motion to ROR. I did receive an email indicating the state had no objection. Can you confirm that the state had no objection on that one? And we can show you the email string we have if they didn't copy you on it.
No, they did not, Your Honor.
Okay, we're just gonna just send you the email string. Okay.
It's okay, Your Honor, there are notes available, and it does say the state has no objection.
All right, court will grant the motion.
Thank you, Your Honor.
All right, thank you, ma'am. All right. All right, what next? Okay. Well, oh. Not for this one, because it's a DUI, so that one's okay. I will need Caesar Chiquines, unless the public defender is waiving. Andrew Martin, I will need Andrew Cool. I'll just get them as I go, because most of them they're 3 traffic, which will be okay. All right. Ms. Public Defender, please let me know if you're waiving on any of these that the public defender is appointed on, and I will be calling through the arraignments at this time. Alec Zachary Kavanaugh, 20.
Medical, yeah.
Medical, Ms. Public Defender?
Yes, Your Honor, I will waive and enter denial.
All right, at this time, this case will be scheduled for,
Division 61,
thank you,
BOP status, February 22nd at 10 o'clock, courtroom 6B.
Cesar Chiquines, 2022 MM 679AO.
Also medical.
Ms. Public Defender?
Yes, Your Honor, I will waive the appearance.
All right,
Enter plea of not guilty, I'm sorry.
case will be scheduled for arraignment, pretrial.
Division 83, pretrial conference, February 21st at 8:30, courtroom 6C.
Andrew Martin Cool, the second, 2022 MM 684AO.
He's medical also.
And I will waive and enter a plea of not guilty, Your Honor.
All right, he does have 2 cases. The public defender is appointed as to the case I just announced. And the second case, 2021 CT 8361AO, the public defender is already appointed. Both cases will be scheduled for pretrial.
2022 MM 684, Division 80, pretrial conference, March 31st at 9 o'clock, courtroom 9C. 2021 CT 8361, Division 82, pretrial conference, March 22nd at 9 o'clock, courtroom 9B.
Andrew Martin Cool, 2021 CT 8362AO. That's the same one. Yeah, same one or third case?
There's no offer.
And the public defender was appointed on that one as well.
I will waive and enter a plea of not guilty, Your Honor.
All right, that will be scheduled for pretrial as well. Kabari Curie Cummings,
Your Honor, oh,
2022 MM 696AO.
and we will enter a plea of not guilty, Your Honor.
Yes, ma'am, that will be scheduled for a pretrial conference. Thank you.
Division 61, pretrial conference, March 4th at 1:30 p.m., courtroom 6B.
You ready for me to do the interpreter?
Yes, we only have one.
Okay.
I don't know what it was said before. Moving on.
Good morning, Your Honor. This is Laura Royo, State Certified Interpreter and previously sworn.
All right, good morning, good afternoon. Carlos Roberto Gomez Gregorio. Case numbers 2022 CT 128AA
Yes, Your Honor. 1 second while I make connection to the podium.
Mhm.
Connection is established.
All right, Mr. Gomez Gregorio, raise your right hand to be sworn in.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Thank you, sir.
Yes, I do.
Sir, the court finds probable cause for the offense of DUI with damage to the property or the person of another one. Bond is set at $1,000. DUI. Bond set at $500, that's count 2. No valid driver's license, count 3. Bond is set at $250. I am appointing the Office of the Public Defender to represent you in your case. Sir, do you have any questions?
Nada más quiero saber si ya pagaron mi mañana.
I'm sorry. I heard someone speak and I was unable to hear the defendant. I'm going to have him repeat what he said.
Nada más quiero saber si ya pagaron mi fianza porque dijeron que hoy en la mañana le iban a pagar. Yo
I just want to know if the bond has been posted. I had been told that someone was going to be posting it in the morning, so I just want to verify that someone has.
I cannot answer the question. However, the administration here at the jail can inform you whether or not your bond has been posted. Thank you.
Gracias.
Thank you.
Laura. I appreciate you.
May the interpreter disconnect, or do you
You
need
may.
it for something else? Thank
No,
you.
Thank you. This, is it next? This is Adiel Omar Isaac Gonzalez. State, I nor the clerk are able to access page 2 and 3 of the affidavit. If the state has it, will be necessary before I can make a determination on probable cause. Page 2 and 3.
I did not have access.
Good morning.
either.
Okay. Nobody has
you-
page 2 and 3?
No, I don't.
No, I have page 1. I don't have page 2 or page 3, and it's not on the clerk's system.
Can you hear me, Your Honor?
Oh, who am I? I hear somebody.
It's all white. This is Attorney Sarah DePalma. I represent Mr. Isaac Gonzalez.
Oh, good afternoon, Mr. Palmer. You were on yesterday, right?
Yes, Your Honor. I
Okay.
have 2.
So, Mr. Palmer, I have been unable to access the full arrest warrant, affidavit for the arrest warrant. I've only been able to access page 1 of 3. And it appears that usually if I can't access something, if the state has it, I'll go ahead and read their document, but they don't have it either. So I don't know what happened. I don't know if it got cut off in transmission when the officer attempted to transmit it to the clerk. But none of us have page 2 of 3 and 3 of 3. Consequently, I'm gonna have to reset the defendant's case.
Okay, yeah, he's in on other things.
Okay, all right, Mr. Gonzalez, sir, I'm going to reset your case for tomorrow, and then somebody needs to contact the officer to get page 2 and page 3 of the affidavit for the arrest warrant, and we'll bring you back in the morning or tomorrow afternoon. Tomorrow afternoon? Whenever we can bring him, the earliest. All right, we'll bring you in the morning. Okay, thank you,
And
sir.
I name
And Mr. Palmer, do you have any other cases?
I do. Would Mr. Isaac Gonzalez be in the 9 a.m. or 11:30?
9.
It's 9. Okay. Awesome.
Yeah, it might not happen right at 9, but that's what time we're setting them for in the morning.
Okay. And I also have Barber.
Did you know that? We got this procedure of letting attorneys call in, they're not, I mean, somebody got to streamline that. An email with the names of the cases that they have. Okay, all right. Oh, okay. Mr. Palmer, did you email about the Barber case?
I did not. I'm sorry. I wasn't aware that I was supposed to.
Okay, Mr. Palmer, ma'am, there is a Division 51 email.
Okay.
Division 51, right? You're going to need to send an email to Division 51 whenever you have defendants that you want to address their cases at IAs.
Okay.
And that's forever until changed. So Division 51 email. I'm going to go ahead on and call this case. So if you just hold on, we'll locate Leon Champion Barber III. And I assume that's your last case, correct?
As far as I know, yes. Your Honor.
Okay, all right. Well, if you don't know, how could I know?
Thank you.
Okay. Mr. Barber? Are you Mr. Barber?
Okay.
Yes?
Yes, ma'am.
Okay, Mr. Barber. Sir, you have two cases. The first case is failure to report vacating a permanent residence as a sexual predator. Count 1, bond will stay set at no bond. Count 2, failure to report a name or a residence change. Bond will stay set at no bond. The third case, failing to register as required, and bond will stay set at no bond. Thank you. Thank you, counsel.
Thank you, Your Honor. Can I be excused?
Yes, you are.
Thanks.
Are there any other attorneys on the audio? All right, we'll assume not. If the attorney doesn't tell us who they're here for, we can't guess it. The attorney needs to tell. And I need to move on because there are cases that are waiting to hear my voice. And then you all can talk to the attorneys in the background, but I gotta move. Okay.
Your Honor, Miss Birdie, Jacqueline, she's medical.
All right, Jacqueline Birdie is medical. I did find probable cause on this case for trespass at the warning. Does the PD want me to appoint them?
Yes, Your Honor. I would ask that you reset for tomorrow. There is an offer to resolve the case.
Okay, I'll appoint the public defender, and this case will be rescheduled for in the morning. Yes, ma'am. Felicia Davis.
She refused, Your Honor.
Felicia Davis. All right, we'll reschedule this one.
No, Your Honor. On this particular case, I would just ask that you set a $250 bond. She has been deemed incompetent to proceed in our out on bond cases, and she does not meet the requirements for commitment.
What says the state?
No objection.
All right, the court finds probable cause, sets bond at $250. However, I was planning on revoking bond, but you're giving me some reasons not to revoke the bond based on her, you said she's mental health case?
Yes, Your Honor.
All right, I won't take any action on the other case. The court is ordering that she not return to the location where this incident occurred as a condition of bond. The public defender is appointed. Edward Allen Dweck. Mr. Dweck. The court finds probable cause for the offense of petty theft. Bond remains set at $250. You're ordered to not return to the location where this incident occurred. Thank you, sir.
Thank you, Your Honor.
Bertram Eric Evans. Is this Mr. Evans? Okay. Mr. Evans. The court finds probable cause for the charge of trespass on property after warning. Bond stays set at $500.
Your Honor, in this particular case, I would also ask for a $250 bond. We have him set for a competency evaluation on March 30th. He's been ROR due to his pending competency issues. He has not been deemed by a court incompetent yet, but he is set for an evaluation on March 30th.
All right. If the state has no objection, I'll be inclined to grant that.
Your Honor, the only thing I note is that
Hold on, Mr. Bertram, I understand.
Mr. Evans has 3 pending charges. 2 of them are trespass. The 2 trespass cases are for the same location as this location. So giving him bond, giving him ROR, he keeps going back to the same location. He has been trespassed from, Your Honor.
Do you have any objection to the motion that's been made to set bond at $250?
No, Your Honor.
Court will set bond at $250. The court will take no action on the pending of the cases. The court is ordering the defendant not to return to the location where the incident occurred.
Is it Carrillo or Murillo? I have Carrillo.
What you want? I don't see where they said they waited. Waited.
Yvonne Marie Murillo.
Yes, ma'am.
The court finds probable cause for the charge of inhalation or possession of harmful chemicals. Bond stays set at $250 in that case. Court will take no action on the cases currently out on bond.
Is there any way that I can ROR?
No, ma'am. Aaron Navon. We'll reschedule Aaron Navon.
Okay, and then I believe the 2 private attorney cases, I'm not sure who's ready.
Carrillo.
Carrillo, ready.
Jonathan Carrillo. Mr. Carrillo, the court finds probable cause for charges as follows. Count 1, trafficking in cocaine. Bond is set at $50,000.
Your
I'm
Honor.
sorry, that's trafficking with a firearm.
Your Honor, trafficking in cocaine over 28 grams with a firearm is actually punishable by life. State asked the defendant be held no bond.
Is there another reason other than that it's punishable by life that you want me to do no bond? Or is that the only reason?
Defendant also does have 3 felonies. They do appear to be drug-related as well, Your Honor.
Were they trafficking?
They were not trafficking, Your Honor.
Were they with a firearm?
There is One of them, which is possession of a short-barreled gun, rifle or machine gun.
Okay, when was that?
One moment, Your Honor.
The information sheet, I mean, unless I'm misreading, it says his last conviction was in 2016.
That may well be, Your Honor.
Am I reading this correctly? Is the defendant's last conviction in 2016? And was the defendant on any type of release or supervision? Does no one know the answer to those questions?
I'm
I'm gonna look it up right now, Your Honor.
Your Honor, from my understanding, if I may, he had, he pled to 2 years of probation and terminated early. So
And
he
that was in 2016?
Yes, Your Honor, he was able to successfully complete supervised community supervision.
Counsel, state your name for the record and spell your last name for the record.
Yes, Your Honor, Harold Thompson on behalf of Mr. Carrillo, Thompson.
All right, state anything else that you can add.
nothing at this time, Your Honor.
All right, bond will be set at $50,000. Count 2, the court finds probable cause, possession of cocaine with intent to sell or deliver with a firearm. Bond is set at $50,000. Count 3, possession of cocaine, bond is set at $1,000. Count 4, possession of cannabis with intent to sell or deliver, bond is set at $15,000. Count 5, possession of cannabis greater than 20 grams with the weapon, bond is set at $7,500. Count 6, possession of a firearm in the commission of a felony, bond is set at $4,000. Count 7, possession of a firearm by a convicted felon, bond is set at $5,000. And possession of ammunition by a convicted felon, bond is set at $5,000. The court is ordering that you possess no firearms or weapons as a condition of your bond. Any other conditions the state would like for me to order?
No drugs or alcohol?
And that you possess and consume no drugs or alcohol and submit to random drug testing and alcohol testing. Any weapons in your possession must be surrendered to law enforcement within 24 hours of your release.
Just, Your Honor, I would like to note that he does have a medical marijuana permit, but I do understand the court's order.
The court will, my order is as to illegal narcotics or narcotics for which the defendant does not have a prescription.
Yes, Your Honor.
Prescribed. Prescription drugs are allowed. Thank you.
Thank you so much, Your Honor. I believe that's it for me. May I be excused?
Yes.
Thank you, Judge.
Naples Rample. Mr. Rample, the court does find probable cause for count 1 aggravated battery, bond stays set at $3,500. Count 2 aggravated battery, bond stays at $150. Count 3 throwing a deadly missile at or into an occupied vehicle, the court sets bond at $150. Criminal mischief, count 4, bond is set at $100. And resisting an officer, bond is set at $100. The court is ordering as a condition of bond that you have no contact whatsoever with the victims in this case. The victims state, are you considering that there are 2 victims in this case or just the driver?
2 victims, Your Honor.
No contact with either victim in this case. Any other conditions that you want me to order?
No, Your Honor. I believe he is the neighbor to the property, so I wouldn't really want to order a no return, so.
All right. Sir, I am going to order, though, that you possess no firearms or weapons. That's a condition of your bond, and you need to surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. And counsel, since you're standing there, why don't you just go ahead and announce your name for the record and go ahead and spell your last name for the record.
Yes, Your Honor, Samantha Angelostro on behalf of Mr. Rampart. It is Angelastro.
Thank you, ma'am.
Thank you.
Anything further?
No, no, Your
Thank
Honor.
you. You're excused, sir.
Thank you, Your Honor.
Thank you, ma'am. Jason Owens. Are you Jason?
No, ma'am, Jason Owens, he bonded, Your Honor.
All right, Jason bonded. Okay. Janine Marie Scaglione.
She's behavior, Your Honor.
All right, we'll reschedule Ms. Scaglione's case. Stephen Tremaine Young. Hello, are you Stephen
Yes.
Tremaine Young? Okay. The court finds probable cause for the charge of criminal mischief. Bond stays set at $500. The court revokes the ROR in the other case, and bond is set at $1,500.
Your Honor, I would ask that you take no action. The state filed a notice of non-filing December 6th.
On which case?
2021. His out on bond 2021 CF 14308.
State, is that correct?
He was arrested November 3rd, Your Honor, and state has not filed formal charges at this time.
All right, the court will take no action as to 21 CF 14308. Shantia Nicole Doherty. Shantia Doherty.
Yes.
Ma'am, you were picked up for failure to appear, and bond stays set at $2,000 for your failure to appear case.
Your Honor, the offer from the state is an adjudication of guilt, credit time served, and no return to 1980 Lake Fountain Drive. I did speak to Ms. Doherty, and she would like to accept the state's offer.
No return to, what's the address again, please?
1980 Lake Fountain Drive.
Lake Fountain Drive?
Yes, yes, Your Honor.
All right. Thank you. I don't have a factual basis on this case. case may have been transferred from another case. I'm not really good at knowing which cases are transferred, and the factual basis is probably in the other case file. If the clerk can give me the case number for the other case, I can look it up. Ms. George?
Yes,
When I look at the information, there are two counts. Count one is possession of paraphernalia, count two is trespass. Is she pleading to both counts, assuming I can find a factual basis?
No, Your Honor, for the state. The defendant was able to complete pretrial diversion for the drug paraphernalia, so the state is only going forward on the trespass.
Okay. Do we have the other case number for the related case? Or? 2560AO. All right. Ms. Doherty, ma'am, is this your signature here at the bottom of this plea form?
Yes, ma'am.
And did you read this document in its entirety before you signed it? Did you have any questions about anything contained on this plea form, ma'am? Yes, ma'am? No? Are you under the influence of any alcohol or drugs or medicine today?
No.
Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes.
All right, ma'am, I reviewed your file. There's a sufficient factual basis. You are alert, you are intelligent. I will adjudicate you guilty. Order that you pay mandatory court costs in this case within 180 days of your release from incarceration. I am ordering your release as to this charge because I'm going to order credit for time served. How much time served does she have?
Total of 2 days.
2 days credit for time served. You must report to the clerk's office to request an extension of time if for any reason you're unable to make the payment of court costs as ordered. You are ordered to not return to the location where this incident occurred. 1980 Lake Fountain Drive. Do you understand?
Yes, ma'am.
Any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. You may exit.
Thank you.
Joseph Perez. Mr. Perez, you were picked up for failure to appear. 2 counts. Bond remains set at no bond on both counts. Thank you, sir. Joanna Rojas. We'll reschedule that. Luis Alfonso. All right, Mr. Alfonso, you were picked up for failure to appear. Bond will stay set at no bond on both count 1 and count 2 of your failure to appear. Thank you, sir. All right, I'm sorry, bring Mr. Alfonso back. He has a second case. Mr. Alfonso, sorry, you actually have 2 cases. The other case, possession of Utalone, the court does find probable cause and bond stays set at $1,000 or PTR on that case. 1,000 or PTR. Thank you, sir. Gosh, I'm totally screwing his cases up. Let me see here. Yeah, we need Mel Alfonso back. Yeah. Mm-hmm. Oh, sorry, Mr. Alfonso, there are a couple of conditions that I'm ordering as a condition of your bond. That you not possess, consume, any alcohol or any illegal drugs or controlled substances without a valid prescription, and that you possess no firearms or weapons. You do need to surrender any firearms or weapons to law enforcement within 24 hours of your release. All right, thank you, sir. You do the same. Ryan Bethel, Mr. Bethel, the court does find probable cause for your offense of driving on a suspended license as a habitual offender. Bond is set or stays set at $2,500 in that charge. You have another case, 2022 CF 209AO. The court will revoke the bond, and bond is set at $1,500. Luxon Calliston. Mr. Calliston, the court does find probable cause for the charge of possession of cocaine. Bond is set at $1,000, and possession of paraphernalia bond is set at $150. Thank you, sir. Joe Terry Collier.
Your Honor, Mr. Calliston was out on bond, out on PTR. Are you going to address that?
Let's see here. Yes, no action. Joe Terry Collier. Sir. The court finds probable cause for count 1, aggravated assault with a deadly weapon. Bond remains set at $3,500, and count 2, possession of cocaine. Bond remains set at $1,000. The court will revoke the bond in case number 2021 CF 14343AO, and bond is set at $5,000.
Your Honor, in that case, again, the state has not filed an information
Okay.
on the out on bond charge, so I would ask that you take no action.
All right. Can the state confirm that?
Yes, Your Honor. Defendant was arrested November 4th. Formal charges have not been filed yet.
All right. The court will take no action on the out on bond case. Sherrod Daniel Dawson. Mr. Dawson, the court finds probable cause for the offense of carrying a concealed firearm. Bond stays set at $2,000, and possession of a concealed weapon or firearm by a convicted felon. Bond stays set at $150. The court is ordering as a condition of bond that you possess no firearms or weapons and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. Thank you, sir. Thank you. David DeBello?
Yes, ma'am.
Mr. DeBello? You were picked up for failure to appear. Bond is set at $100.
Is that time still running?
Mr. Patrick Wayne Donald? Mr. Donald? Sir, the court does find probable cause as to count 1, possession of paraphernalia. Bond is set at $100, And count 2, possession of 3,4-methylene, methamphetamine, MA ecstasy. Bond is set at $1,000. State, are you asking for any additional conditions other than the bond?
No drugs, no alcohol, Your Honor.
No. Leandre Tavares Harrison. All right, previously bonded. Ariel Ross Dumont. You were picked up for failure to appear. Bond will stay set at no bond in that case. Nicole Hickman. Ma'am, you were picked up for failure to appear, and bond will stay set at no bond.
Thought I had a $5,000 bond.
Yeah, this one has a discrepancy in it, actually. Yeah, I do remember seeing that.
I was in jail here for 3 weeks. I got out the day before that court date, and they told me my next court date was the 2nd. I had no idea.
I think I'm gonna set it at $5,000, because on one
Is there
piece
any
of.
way you can set it cheaper? I just bonded out last Wednesday, the day before this court date. I had no idea.
Well, looking here at the paperwork, the judge either set it at 5,000 or they set it at 0. I'm gonna go with the 5,000, and I'm not gonna set it any lower, because either the judge set it at 5,000 or the judge set it at 0 bond. And I have paperwork here for 5,000, but I also note that on the arrest affidavit, the bond is no bond. And so one of them is wrong, and I'm giving you the benefit of the doubt and using the 5,000.
Thank you, ma'am. They told me, the cop told me I had a $5,000 bond as well.
So we're gonna use that, and that's, hopefully that's the correct one. All
Thank
right?
you very much.
All right, thank you.
And I have no holds.
I'm not aware of any, ma'am.
Okay, thank you very much.
Darrell James. Mr. James. The court does find probable cause for aggravated assault with a firearm, and bond stays set at $5,000. The court is ordering no return to the location where this incident occurred, no contact with the victims whatsoever in this case. Okay, no contact with the victims, that you possess no firearms and possess no weapons as a condition of your bond, and surrender any firearms or weapons to law enforcement within 24 hours of your release. Further, the court is revoking the PTR, pretrial release, and ordering no bond on all counts in case number 2021 CF 1597280. Thank you, sir. Verinda Law.
Yes.
The court finds probable cause for the charge of intimidating or sending written threats to commit bodily injury, and bond stays set at $2,500. The court is ordering a revocation of the bond on case number 2022 CF 85580, and bond is set at no bond.
I don't got no bond?
You don't have, yes, as to the second case, no bond. Yes.
But I didn't.
There was a bond, but I revoked it. And now there's no bond. Are you Mr. Law?
Yes, I'm Mr. Law, but may I speak? What happened? Like,
No.
Miss, the public defender and the state, please approach. Mm. Oh, no. Is that Mr. Law or is that Mr. Law? Two different people.
I mean, this guy is trying to rob me my truck.
I don't know. Are you Virendra Law?
Yes.
Maybe they just mistakenly put the wrong picture with it.
He's my cousin. He got my truck, and now he don't want to pay me. So he's trying to rob me like $18,000.
Well, he says he's that person, so. All right. All right. Yes, the order will remain as the court has announced. No change. Jasmine Yvonne Monroe. Ms. Monroe, the court finds probable cause for first-degree murder. Bond remains set at no bond. That's count 1. Count 2, carjacking with a firearm. Bond remains set at no bond. Count 3, tampering with physical evidence. Bond remains set at $5,000. Conditions of bond are that you have not returned to the location where the incident occurred. Any other conditions state?
No contact with the victim's family and no contact with the co-defendant.
No contact with the victim's family. Court is ordering that, and the court is ordering no contact with the co-defendant.
I apologize, Your Honor. No contact with victim's family or any other witnesses.
Yes, ma'am, I will include that. The court is further ordering no contact with any witnesses involved in this case.
Thank you, Your Honor.
The court is ordering that you possess no firearms or weapons as a condition of bond, and that you surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. Thank you.
Thank you, Your Honor.
Yes. Brendan Newton. Mr. Newton,
Yes, ma'am.
the court finds probable cause in your case for grand theft of a motor vehicle. Bond stays at $1,000. The court is revoking the ROR in case number 2021 CF 85880 and setting bond on count 1 at 1,000 and count 2 at 500.
Yes, ma'am.
The court is ordering that you not return to the location where this incident occurred as a condition of your bond and have no contact with the victim. Thank you. Monica Lynn Ogle. She bonded, Your Honor? All right, thank you. Anthony Antonio Roberson. Mr. Roberson, as to your case, the court finds probable cause for failing to register as a sexual offender. Bond stays set at 1,000, and failing to report a driver's license change, and bond stays set at $1,000. Thank you, sir. Jalen Ja'Cory Swepson.
Yes,
Mr.
ma'am.
Swepson, the court does find probable cause for possession of a firearm by a convicted felon, and bond stays set at $4,000. Or PTR. And count 2, possession of ammunition by a convicted felon, bond is set at $150 or PTR. Conditions of bond or PTR that you possess no firearms or weapons, and you surrender any firearms or weapons to law enforcement within 24 hours of your release. That you have no contact with the victims in this case. State, do you have any other conditions that you're suggesting or requiring on this case?
No, Your Honor.
Thank you. Jamarius Jamal Walker.
Yes, ma'am.
Mr. Walker,
Yes, ma'am.
the court finds probable cause in your case of attempted first-degree murder with a firearm. Bond remains set at no bond. The court revokes the bond in case number 2020 CF 6595AO, and bond is set at no bond in that case.
Okay.
All right, thank you, sir. Javon Maurice White. Javon White. The court finds probable cause in your case, Mr. White, for first-degree murder. Bond stays set at no bond. Court finds probable cause for carjacking with a firearm. Bond stays set at no bond. The court is ordering that you have no contact with the victim or the victim's family. The victim's family. And that you have no contact with witnesses involved in the case, and that you not return to the location where the incident occurred. And that you have no contact with the co-defendant. That you possess no firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of release. Thank you, sir.
So you're all set.
Joe Wilson. Mr. Wilson? Sir, the court does find probable cause for your charge of grand theft, and bond stays set at $500. The court is revoking your bond in case number 2021 CF 14651AO, revoking your ROR status. And bond is set at no bond on count 1 and count 2.
Your Honor, I would ask that you take no action. On January 21st of this year, the state filed a notice of non-filing.
All right, State, can you confirm that?
Yes, Your Honor. Defendant was arrested December 19th, and as of yet, state has not filed any formal charges.
The court will take no action as to 2021 CF 14651AO. Thank you. Thank you, sir.
You're good.
Anything further?
Nothing from the state.
Nothing from defense, Your Honor.
Clerks? Okay. Anything else on the record? No. Court stands in recess.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.